on your YouTube channel, the United States of America, State of Florida.
Well, good morning and welcome to a morning session of the 5th District Court of Appeals. We have 4 cases on our docket today. The first is criminal, the others are civil. Let me introduce the panel before I go too much further. On my right is Judge Jackie Kennedy, and on my left, Judge Richard Orfinger. That sometimes gets confused, as in Tuesday. But we have 4 cases today. The first is a criminal case, which will have 15 minutes per side. The others are civil cases, and will have 20 minutes per side. There is a clock on the podium for those of you who have not argued here before. If you want to reserve some time for rebuttal, and you want me to help you out with that, let me know, and I will be happy to give you a heads up when you reach that time. Now, if you have anything that has an on-off switch, we'd appreciate it if you would turn it off right now so that those arguing will not be interrupted. With that, let's begin with the first case, Moser versus State of Florida.
Good morning. My name is Steve Plotnick, and I represent the appellant, Scott Moser. This is a case of prosecutorial comment on the appellant's right to remain silent after being Mirandized but before trial. Essentially, the case breaks down into 3 parts. The first part occurred at trial. The prosecutor was cross-examining the appellant. The appellant had previously testified, and there was no mention during the entire trial of anything involving an invocation of the appellant's right to remain silent. There was a deputy that was asked several questions, really very, very brief. I think there were 5 questions about what the appellant said, and they were very, very brief, hardly anything. There was no mention that the appellant invoked his rights. Nothing, and then the appellant testified, and he was not asked on direct anything about statements that he gave to law enforcement. That came when the state began to cross-examine him.
Well, now the statements that he gave to law enforcement were post-Miranda.
Yes.
And what is wrong with using those statements at trial?
Absolutely nothing. That was fine. So the original state's case, the direct part of the state's case, there was no problem with that, the state's case in chief. The problem came on the defense side. Appellant took the stand, and during his direct examination, there was no mention, he was not asked any questions by his attorney concerning statements given to the police. On cross-examination, although actually there was no objection, this was beyond the scope of the direct examination, but the prosecutor began to ask the appellant, so you were given your Miranda rights, isn't that correct? Now, as I mentioned, this is beyond the scope of direct, but there was no objection. And the appellant said yes, and he began to ask him some questions about what he told the deputy, and finally...
Well, these were questions in impeachment of what he'd said on his direct examination, right?
It was an attempt at impeachment, yes.
Yeah, he said, did you tell Deputy Reynolds that you believe that you saw Mr. Schmelzer at the Fish on Fire? Answer, no.
Well, you know, that didn't...
But, you know, that's the kind of...
the purpose was to impeach the appellant. But what happened is, near the very beginning of the cross-examination, the appellant said in open court, the deputy kept twisting stuff around, so I just said, I'm not talking no more. That's a direct quote from the record. That is a direct and unambiguous invocation of his right to remain silent.
Wait a minute. When? Are you saying it was an invocation of his right to remain silent at the trial?
No. This was a question, the appellant was being questioned concerning what had happened at the scene. In other words, the deputy had earlier testified in the state's case in chief that he had questioned the appellant. And the appellant gave some very brief answers, and he really didn't question him anymore. Now, on cross-examination, the appellant has taken the stand in the defense case, and the appellant was asked, You were Mirandized, right. So it starts right out of the beginning of cross-examination. The prosecutor has now established that Miranda warnings were given to the defendant. And within 3 questions of the prosecutor, the appellant said, in effect, not in effect, he said, "I'm not talking no more." The deputy was twisting things around, so I said, "I'm not talking no more." This was a statement by the defendant at trial that he had invoked his Miranda warnings. What should have happened at that point is the state should have abandoned its questioning, or it maybe approached the bench and said, "Your Honor, we're running into an issue here. I'd like some..."
Was there an objection to that?
Not at that point, not yet. Then, as you noticed, the impeachment began. He began asking, after the appellant said, "I'm not talking no more," I told the deputy I wasn't talking no more, then the impeachment began. And the impeachment was a series of questions about what he had decided not to tell the deputy. And there were a series of questions. I think you referenced them. Did you tell the deputy about getting into about Mr. Smeltzer getting angry with you, trying to get his car fixed? No. Those questions are, quote unquote, fairly susceptible to the jury to being a comment on his right to remain silent. Those questions, parenthetically, were really, after invoking your Miranda, did you tell him about getting angry? No. After invoking your Miranda, did you tell Deputy Reynolds that you believed you saw Mr. Smeltzer at the Fish on Fire? No. After invoking your Miranda, did you tell the deputy that you first saw Mr. Smeltzer at the carport? No. That's what the prosecutor is really saying, and that's why it's fairly susceptible to the jury that these were comments on his right to remain silent. He asked a series of questions like that, and the prosecutor was ending his cross-examination by saying, "So you've had approximately 6 months to conjure up this story." And that's when appellant's defense attorney at the trial said, "Objection, he's calling on him to comment on his right to remain silent prior to trial." He gave a very precise objection. I believe that preserves the objection. The judge overruled that objection.
He moved to strike the previous stuff?
He did not move to strike it. But nonetheless, he did say, the court said, "I'm going to overrule the objection, but I'm not going to allow you to ask that question." I believe under those circumstances, the error was preserved because there was an objection. It stated precisely what the grounds were, that this was a comment on his right to remain silent prior to trial.
Didn't the trial judge, in effect, sustain the objection?
Well,
He says, "I'm not going to let you ask that. I'm not going to sustain the objection, but I'm not going to let you ask the question." It sounds to me like he sustained the objection.
well, but he said, I know what you're saying as a practical matter, but he said it was overruled. That's what, your objection is overruled. He said, "But I'm not going to allow you to ask the question." However, the question was already asked. And in other words, it was out there. The old saying, you can't unring the bell. The question was asked, the jury heard it. And the importance of that is concerning the harmless error test. I never heard it pronounced, I think it's DeGuilio, which was a comment on the right to remain silent. That case said very clearly that if the comment is fairly susceptible by the jury as being a comment on the right to remain silent, that the state has the burden to prove beyond a reasonable doubt that the error did not contribute to the verdict. And I believe under these circumstances, it's very clear from the record that this comment did contribute to the verdict. In other words, the question that you asked concerning the judge's ruling, since the comment was out, the question was out, the impeachment was in effect over. The prosecutor had demonstrated to the jury that this man is essentially lying because he's had 6 months to conjure up this story. And under the case law, the focus is on what the jury heard. The trier of fact now heard this. The trier of fact was now under the impression that Mr. Moser probably made up this whole thing. The reason that this is so important is because this case rests on self-defense. And Mr. Moser, the appellant, was the only person who could give his self-defense defense. And if he is shown to be a liar, if he is shown to be non-credible, then that strikes at the very heart of his defense. And that is what the prosecutor did. And that's why, as I say, I think the trier of fact was clearly affected by this error, which should not have been permitted, which should not have occurred.
It bothers me some that there was no objections until we got down to the one last question. Then there's an objection which is ambiguously sustained, and there's nothing else after that. I mean, what about all those questions that had previously been asked that had not been, there was no move to strike, there was no motion for mistrial, they just sit there?
I understand that. I was not trial counsel at the time. I cannot explain why there was a delay. However...
I mean, regardless of what the explanation is, that's what happened.
Yes, that is what happened, but finally an objection was...
damage done, it was then, not at the question that was not permitted to be asked.
I understand that. The only thing I can say is, although there was some damage done, apparently counsel did hear the question once it was asked, the final summation of the question, so you had 6 months to conjure up this story, and that's when he made the objection, and that's when it was overruled. I believe he did preserve the error, and that's why...
Do you think he preserved the error as to the questions that were not objected to, not moved to strike, and without a motion for mistrial?
Well, I think that's a close question, but I believe that he did preserve that error. In other words, there was a line of questioning, and finally he said, wait a minute, this is wrong. These are comments on his right to remain silent prior to trial, and I object, and that's what was overruled.
Is that the old can't unring the bell thing? I mean, that bell has already been rung, hasn't it?
The bell had been rung, but the objection was made, and that's why I believe there is harmful error here, because the prosecutor was allowed to make those comments.
The whole purpose of the contemporaneous objection rule is to give the trial judge an opportunity to fix the problem early on. If there was a problem at all, the horse was out of the barn by the time the objection was made. I mean, he made it in a series of 10 or 15 questions. Instead of making the objection on question 1 or 2, he makes it on the last question.
That's correct.
So, I mean, the horse, if there's a horse out of the barn, it's gone.
That's correct, but he still did make the objection.
The retroactive objection rule?
Springing executive.
Well, I'm not asking the court to create a retroactive objection rule, but I believe that there was an objection. It was properly stated, and the only thing, once the judge announced that I'm going to overrule, but I'm not going to allow you to ask the question, I think that counsel probably couldn't do anything more. In other words, the judge has now overruled his objection, and counsel may have felt, and I don't know.
But what happens from that point on? I mean, there's no objectionable stuff that occurs after that point, is there?
No, there was no objectionable
There wasn't anything else for counsel to do because the state didn't ask any further questions that were arguably objectionable.
That's correct. There were no arguably objectionable facts, and in all candor, the state, in fact, did not comment on this in closing argument or anything else, but it made these comments. And under the harmless error test, it appears clear that these comments affected the jury's verdict because the issue was self-defense, and Mr. Moser was the only person who could give his defense.
Counsel, you only have about 2 minutes left.
Yes.
I want to save those for rebuttal.
Okay. I will. Thank you very much.
May it please the Court, my name is Ann Phillips. I'm here on behalf of the state of Florida. It's the state's position that no error occurred in this case. We'd first argue that there was no preservation of this issue. The Court, while it did state the word overruled, it in fact sustained the objection, which would then require a request for either a curative or a mistrial, which didn't occur in this case. I think based on the exchange that you just had with appellant's counsel, you can see where, had that occurred, we would have been able to get further in this, that this in fact was not a preserved error. Even if you do want to say that something was preserved, it would have only been as to that last final question. It certainly didn't affect anything else. The state would dispute that the defendant even did invoke his right to remain silent. There's no testimony anywhere in the trial that he did do that other than his self-serving statement, and I'm not even sure it can be interpreted as an invocation of his right to cease questioning and re-invoking his rights. He said, "I said I'm not talking no more." That in itself shows that he had been talking to the police, and therefore any of those statements that the state had commented on previously were fair game, because he can't unring that bell himself. To revoke a prior waiver after answering questions, you can't retrieve those answers and bring them back too. So even if we're not talking about anything he said after he invoked his right, everything was before. I believe it was fair game. He took the stand. The state was allowed to impeach him and to bring out any prior inconsistencies in his testimony. It was never mentioned again in closing, so I think we passed the harmless error test here, and unless there are any specific questions, we'll rely on our brief.
Thank you.
Well, very briefly in rebuttal, I would simply say that it's not a self-serving statement. The appellant was up on the stand. He was simply asked by the prosecutor on cross-examination concerning what he had said, and he is not a sophisticated law school graduate or law professor. He simply said, "I told the deputy I wasn't going to talk no more." That is an invocation. The cases are very clear that one may answer some questions and then invoke his right to remain silent at any time during questioning, and that's what happened here. So I believe there was an invocation. We discussed whether it was preserved. I believe that the objection did preserve the error, and I believe that this error was not harmless. The state has not, quote unquote, proven beyond a reasonable doubt that this error did not contribute to the verdict. So I would ask this court to reverse this conviction. Thank you very much.
Thank you, counsel. All right, we'll now take